Meeting 8 of the Senate Standing Committee on Education will come to order. Please call the roll.
Senator Carroll.
Here.
Senator Givens. Senator Higdon. Senator Meredith. Senator Neal. Senator Rawlings. Senator Reed. Senator Thomas. Senator Tishner. Senator Williams. Senator Wilson. Senator Wise.
Present.
Chair West.
Here. We have a quorum. We are duly constituted to conduct business. We'll immediately go into the rules of the committee. These are the rules we read and proceed with every meeting. Please silence your cell phones. No signs are allowed in committee rooms. If you wish to speak for or against a measure, you need to sign up at the sign-up sheet in the back as you come in. Do any members have introductions? Wow, that's maybe a first. Okay, no introduction. Up for consideration first, we have Senate Concurrent Resolution 76. A concurrent resolution directing the Legislative Commission to establish the Kentucky School for the Deaf Governance Task Force. Senator, make sure the green button's on. State your name for the record. The floor is yours. Please proceed.
Thank you, Chairman. My name is Amanda Mays Bledsoe. I'm the state senator for District 12, which includes Mercer, Boyle, Woodford, Mercer, Boyle, and Fayette. Sorry, out of order.
The floor is yours. Please proceed.
Thank you. So just for a little history, the Kentucky School for the Deaf was first created by the Kentucky General Assembly April 10th, 1823. It was one of the first established schools for the deaf and the very first one established with public funds. Very unique, very innovative program back in the day. As you know, today it is a very different world in the deaf community, and there's lots of different advancements and technologies that have allowed, with cochlear implants and other things, for people not to use sign language as much. Some have gone basically to just using lips and other things, but the school has gone through a lot of changes over the last 100 or so years. One of the questions that they have continuously kind of tried to advocate for is a better governance and a better relationship between maybe their school and the Kentucky Education Department. For many people, this only serves about 100 people, in our school system. And they are few but mighty and just would like to have a little bit more voice and attention to some of their concerns. So this would establish a task force with some legislators as well as some members of that community to kind of see what the future of the deaf school might look like in today's environment.
Motion on the bill.
Thank you so much. We have a motion on the bill. Senator Wise, second from Senator Wilson. Please call the roll.
Senator Carroll.
Aye.
Senator Givens.
Aye.
Senator Higdon.
Aye.
Senator Meredith. Senator Neal.
Aye.
Senator Rawlings.
Aye.
Senator Reed.
Aye.
Senator Thomas.
Aye.
Senator Tishner. Senator Williams. Senator Wilson. Senator Wise.
Aye.
Chair West.
Aye. Senate Concurrent Resolution 76 passes unanimously with favorable expression.
Thank you so much.
Thank you, Senator. Up next on the agenda, we have Senate Concurrent Resolution 131, a concurrent resolution directing the Legislative Research Commission to establish the Efficient and Effective Districts Task Force. That is Senator Wise. I believe he's going to present that from his seat.
Thank you, Mr. Chairman. Members of the committee, I will present from here if that's okay. Max Wise, State Senator, 16th Senate District. Members, what we have before us is Senate Concurrent Resolution 131, which actually is a carryover from the 2024 task force of the same name, Mr. Chairman. I do want to thank those members that were a part of that task force, some which are on this committee, others on the House on their side. I think they met about 10 times over the course of that interim period of 2024, and we would like to continue that. I cannot say at this time if we will meet 10 times over the interim like they did previously, but with that, we just want to continue taking a deeper dive and understanding as it relates around student achievement, especially from those school districts across the Commonwealth, Mr. Chairman. So this is just a continuation of that. This will be, though, legislator only. The previous task force, from my understanding, had different various individuals a part of that. It was the recommendation while meeting with the co-chairs of that task force, if we do continue this, that it would be more of legislator only for that task force. But similar topics, and I think a lot of the policy you've seen that was developed this session of the General Assembly just need to be continued to looked at, of bills that may have passed or other bills that did not make its way through this legislative session, Mr. Chairman.
We have a motion on the bill from Senator Wilson. We have a second from Senator Meredith. Please call the roll.
Senator Carroll.
Aye.
Senator Givens. Senator Higdon. Senator Meredith. Senator Neal. Senator Rawlings.
Aye.
Senator Reed. Senator Thomas. Senator Tishner. Senator Williams.
Aye.
Senator Wilson. Senator Wise. Chair West.
Aye. Senate Concurrent Resolution 131 passes unanimously with favorable expression. Thank you, Senator Wise, for the presentation. Up next, we have House Bill 240, an act relating to primary school. Representative Truitt, whenever you're ready, please state your name for the record and proceed.
Representative Truitt, 89th House District, representing Jackson Lee Wolf, part of Laurel, part of Madison. Thank you, Mr. Chairman and committee. I really want to throw a thank you out to Chairman West, who reached out over the weekend and kind of worked with me on an amendment to take a good bill and make it better. And I appreciate that, appreciate him doing that and sharing the amendment with me. So what this bill does it kind of talks a little bit about what we are, we can already do some of these things. All right, in elementary school, we have what you call ungraded primary, which means we as a school get to decide when it's time for a kid to move on from kindergarten, first grade, second grade, and so on. You've basically got 4 years to make it through 3 years of instruction. The problem is when parents sometimes hear the word ungraded, sometimes they think that there's nothing they can do to be held back. They must go on and stay with their peers. So what this bill will do is this. I'll start with the original bill. The original bill in the House basically said if a student is not ready when they're in kindergarten to move on to first grade, that they must repeat kindergarten one additional year to try to make sure we get those foundational skills. Okay? This is something I already currently do in my school. It's been one of the biggest difference makers that I have. You know, it makes common sense. If you've got a student who isn't ready in kindergarten where they are learning to read, to send them to first grade where they're reading to learn when they're not ready. So this is something that I already practice, and it's a game changer for me in my school. Talked to a lot of different principals, superintendents, teachers, and so on. A lot of districts don't have the courage to do this because there is pushback sometimes from parents. Sometimes, you know, the moms and dads want their kids to stay with their peers and move on regardless whether or not they're ready. So, as you know, with Read to Succeed that we passed a couple years ago, we're already requiring students to take these universal screeners. They will take 3 universal screeners throughout the year. What my bill requires is they take that last universal screener the last 14 days of the year to line up with KSA testing, and also to allow the teachers, you know, the aides, the interventionists, to get as much knowledge as they can into those little brains. The amendment, what the amendment does is the amendment says that a school may hold a kid back in kindergarten, but they shall in first grade. So in other words, it gives the district, the principal, the teachers, the school, the ability, if you've got a kid who's struggling in kindergarten, but we think it may be able to be addressed in first grade, to let them have another shot in first grade before we say you shall do this. Okay? So I like that. I have no issue whatsoever with that. I do the same thing. If we got a kid that's borderline, we say, let's try them in first grade and let's see what we can do. So I think the amendment makes the bill much better. I think that this, even though it's very simple and it's something we can already do, I think this bill could be earth-shattering when it comes to reading proficiency in third grade later on down the road. Think about foundation. Think about building a house. You know, nobody building a house would build a halfway sound foundation. They would make sure that foundation is the most important. So that's the importance of this bill. We want to make sure our kids are ready. A lot of states are doing this in third grade. In my personal opinion, that's too late. All right, we need to do it down there in kindergarten or first grade to make sure those kids are ready to learn. It's not changing anything about their reading plans. You'll still do the tiered 1, tier 2, tier 3 instruction. It just allows the school to kind of blame us. Let's put it that way. We're taking the cover. We're taking the blame for a kid not being able to move on just because little Johnny is his best friend and he needs to repeat kindergarten or first grade. I hope that kind of gives you a roundabout idea of what the legislation is. Be happy to answer any questions that you have about this bill or this amendment.
We have a motion on the sub. We have a second on the sub. All those in favor of adopting the sub say aye. Aye. Opposed, nay. Ayes have it. Sub is adopted. Any further discussion, Representative Truitt?
I'll just answer any questions they have any.
Any questions from members? Seeing none, do we have a motion? We have a motion on the bill from Senator Givens. We have a second from Senator Tishner. Please call the roll.
Senator Carroll.
Aye.
Senator Givens. Senator Higdon. Senator Meredith. Senator Neal. Senator Rawlings.
Aye.
Senator Reed.
Aye.
Senator Thomas. Senator Tishner. Senator Williams.
I'd like to explain my aye vote.
Please proceed.
As we talk, this is great. We homeschooled 6 kids. The one that you've heard me say it before, the one that learned to read the latest. He might have been pushing your 3rd grade limit, okay? He is the best reader today. And if we had not pushed him, if we pushed him too early, he would have turned off. We had to wait till he was ready to read. And then once he did, he read, and he keeps doing it. He runs 3 bookstores. So I would say we're looking at performance-based advancement. And even in the 3rd grade, if he can't perform and can't do the basic reading, I would have some concerns. This is a step in the right direction. I'm all for this bill. But I think we need to go to performance and not just age or time in the seat kind of advancement. So I vote aye. Thank you.
Senator Wilson. Senator Wise. Chair West.
Aye. House Bill 240 passes with favorable expression unanimously. Representative Truitt, I appreciate you working with me over the weekend on the sub.
All right.
Really great bill.
Thank you, guys.
Thank you. Up next, we have House Bill 298. Representative Tipton, an act relating to schools identified for comprehensive support and improvement. You know the deal, Representative.
Thank
State
you,
your name
Mr.
for the
Chair.
record, and the floor is yours.
Representative James Tipton, House District 53, which includes Anderson and Spencer County. Mr. Chairman, members of the committee, I appreciate the
Could you make
opportunity.
sure that mic is...
Okay, I'll try and pull it a little bit closer.
Yeah.
How's that?
Thank you.
Appreciate the opportunity to talk to you about House Bill 298. Mr. Chairman, I want to thank you for helping me take 298 from a really good bill to a really great bill. Comprehensive support and improvement is a federal designation from ESSA that currently in Kentucky law, schools are identified every 3 years. If they fall on that bottom 5%, high school does not meet 80% graduation rates, or if they had previously a TSI school that has not made advancement. 2 years ago, we had 28 schools in the state of Kentucky identified for CSI status. Last year, there were 20. Of course, we were not identifying any new schools. So I asked the question, if we had been identifying last year, how many additional schools would have been identified? KDE gave me a list of 34 schools, additional schools across the state that would have been identified. I feel like it is vitally important that these schools that are having issues, their students are having difficulty, to get them the support. When a school is identified for CSI status, KDE goes in, they do a management audit. What House Bill 298 would do, it would require annual identification, instead of identification every 3 years. It would also, through that management audit process, it would allow the KDE to make recommendations to the superintendent on the ability of the principal to do a turnaround at that school. It would also require professional development, especially in reading and math, for those teachers in those schools identified as CSI, and it would require the superintendent of those schools to use effective, high-quality instructional resources in those schools. The committee sub did make one change to this part of the bill, and that is on the turnaround teams. It would allow school districts to have more than one school identified for CSI to actually contract for a turnaround vendor. Now to the rest of the bill. For the past 3 years, I've been working on this issue of employee misconduct in schools. All too many times, we hear and read about stories where adults in supervision that have authority over students in school take advantage and do inappropriate activity. 2 years ago, that was House Bill 288 that passed out of the House by a vote of 97-0. We passed that bill through Senate Education that year, but in that short session, it did not make it all the way through. Last year, House Bill 275 passed 95-0. It passed the Senate 35-0 with a committee sub, and in the end of the days, it was not concurred on. So I filed House Bill 36 this year, and the short session had not been heard. And I appreciate the chair's willingness to add this bill, this important piece of legislation, to 298, and it is 99.5% of what we had last year. One minor change in the bill. I'll be happy to entertain any questions either members may have on either one of these components of the bill.
Before we get to those, would you like us to adopt the sub?
I think that'd be great, Mr.
I'll
Chair.
make a motion on the sub. Do we have a second? Senator Wilson with a second. All those in favor of adopting the sub say aye. Opposed, nay. Ayes have it. Sub is adopted. Any questions from members for Representative Tipton on the bill itself? Senator Givens.
Mr. Chairman, thank you, and I'll be brief. Chairman Tipton, thanks for your leadership on this. I know this has been a passion of yours for some time, and I applaud you for finding a way forward with the help of our very able chairman here on the Senate side to navigate this path. You mentioned the 99.5% is the same as what you've had in the past. Share with me what the 0.5% difference is, if you would.
Sure, Mr. President. In section, give me just a second to find my notes here. In section 3, subsection 6, the word investigation was removed.
What page are you on?
That would probably be on, let's see, page. Looks like it's going to be on, find the right page here, because the pages are different in the original bill than the sub because of the difference.
I think it starts around page 18 in the sub, maybe.
Okay, yes. In the original bill, yes, thank you. There in the original bill, there is a reference to. It'd be simpler for me to go with the original bill because I know what's changed in it. In the original bill, in that section, it says each application for a school district position shall require the applicant to, number one, disclose. In the original bill, it said being the subject of an investigation or a disciplinary action within the past 12 months. The word investigation was removed, and the term being part of a disciplinary action in the past 12 months. And in that section, the reference to an investigation was removed from all part of that subsection.
Very good, thank you.
Any other questions from members? Seeing none. Do we have a motion on House Bill 298 as amended by committee sub? We have a motion from Senator Tishner, second from Senator Rawlings. Please call the roll.
Senator Carroll.
Aye.
Senator Givens.
Aye.
Senator Higdon. Senator Meredith. Senator Neal. Senator Rawlings. Senator Reed. Senator Thomas. Senator Tishner.
Explain my vote.
Please proceed under 3 minutes.
Representative Tipton, I'm going to vote aye, and I just want to commend you for your work on this. It's a great piece of legislation and very, very necessary. Thank you.
Senator Williams. Senator Wilson. Senator Wise. Chair West.
Aye. House Bill 298, as amended by committee sub, passes unanimously with favorable expression. We have a motion. There is a title amendment. The title amendment has been distributed to all members. It's in your packet. We have a motion from Senator Wilson to adopt the title amendment. Do we have a second? We have a second, Senator Tishner. All those in favor of adopting the title amendment say aye. Aye. Opposed, nay. Ayes have it. Title amendment is adopted to House Bill 298. Don't go anywhere, Representative Tipton. Chairman Tipton. Up next on our agenda, we have House Bill 424, an act relating to employment at public post-secondary education institutions. That is also your bill, and the floor is yours.
Thank you, Mr. Chairman. I am still James Tipton, House District 53. House Bill 424 came about I've spent a lot of time in my term in the General Assembly working with the post-secondary education community. I've listened to a lot of stories. I've heard a lot of situations that have happened on campuses over the years. And 2 or 3 main changes it does. Currently in Section 1, that refers to our comprehensive universities, KCTCS. Statute actually said that the board may appoint a president, so here it says they shall. The change in here would give faculty member and employment, appointment, and removal decisions could be delegated to the president if chosen by the Board of Regents. So those are the 2 main sections in that. The main emphasis of the bill is that each Board of Regents would adopt a performance and productivity review process for all of their faculty, for all their professors at the post-secondary level. This would happen at the minimum of once every 4 years. In talking to our schools, most of them are already doing this, and some of them are doing it more often than once every 4 years. But it would require this process at least once every 4 years, provided to all faculty members. And also in our statute, there is a term for cause for how a faculty member could be removed. Currently, they can be removed for an incompetency, neglect of or refusal to perform his or her duty, or immoral conduct. And it would include in the definition of cause failure to meet college, university performance and productivity requirements as determined in accordance with subsection 2 of this section. That's basically the emphasis of the bill. I'll be happy to entertain any questions, Mr. Chair.
Thank you, Chair Tipton. There are no committee subs for this particular bill. Do we have any questions from members on House Bill 424, Senator Neal? I'm sorry, I didn't hear you. Oh, I apologize for that. Do you want to present that? Is that your sub? Okay. Chair Tipton, Senator Neal, I believe, is going to come down there and present on a sub. Senator Neal, do you want the sub distributed to members? Thank you. Whenever you're settled, hold on a second, Senator Neal. We're going to wait and make sure all these subs are distributed.
Is this the new language? That's the new it is. This is old language. Oh, it's just an addition of one line, one sentence. What's this right here? That's already in there. That's already in there.
Does everyone have a copy of the sub? Okay. Senator, if you would state your name for the record and your guest, and as soon as you've done that, you're free to proceed. The floor is yours.
Thank you, Mr. Chairman. My name is Gerald Neal. I'm Senator for the 33rd Senatorial District in Louisville, and I have with me Dr. Ray Horton. Dr. Horton is with the United Campus Workers for Kentucky. He is an associate professor of English at Murray State. He is speaking in his personal capacity, not on behalf of the employer.
Thank you so much for having us today. So during the House floor discussion, and I believe a little bit today as well, Representative Tipton reiterated that the bill is not intended to be an erosion of tenure. It's merely designed to reinforce accountability on employment contracts. I spoke with the leadership of the Coalition of Faculty Senate Leadership in Kentucky's universities, with Kentucky's AAUP chapters, American Association of University Professors, as well as United Campus Workers of Kentucky Leadership. And we agreed that we want to take Representative Tipton at his word on that. And we propose a very, very small change to this bill. It would just be one sentence that would be added into 3 different places in the bill. It's one sentence each time performance and productivity is defined. And the sentence essentially asks that any measure being used to evaluate performance and productivity, any measure established or process established by the boards would only be stipulated to existing employment contracts that the faculty being evaluated through post-tenure review have. It doesn't seem on its face like a huge change, but in terms of the concerns many faculty have presented, concerns that have happened in other states as well, where changes have been made to the post-tenure review process, that little barrier to prevent, the inadvertent imposition of criteria that are outside of the scope of the faculty's employment contract is just a way to make sure you have that safeguard, because so many of our faculty at our universities, I'm an English professor, I'm evaluated very differently than a physics professor, very differently than a med school professor. This just keeps the evaluation strictly to the employment contracts. And I'm happy to answer any questions.
Senator Neal, do you have any comments?
No, I don't think I have anything to add to that. It seems like a step, I think, that would bring some integrity to the process. I don't think it's contrary to what the original bill is about. I think it makes it better.
Senator Givens has a question.
So, Mr. Chairman, the first question, does the sponsor have a copy of the proposed sub?
I do not.
Okay, if we could get him a copy of the sub, that would be helpful. And this is, Senator Neal, to use a phrase that we often hear around this place, this is sure at the last second. If we could have seen this sooner, we could have had time to chew on this and think about this. This would have been really good for us to have seen sooner than this.
Well,
But I've never had the chance to use that phrase before, so I get the chance to use it now.
I know, but I got to respond because you used it. I think you have a good point, but you know how it is up here. Things evolve, things come to your attention, and we are here, and we do have the ability to make this happen. I think if we slow down just a moment and deliberate on exactly what's being presented here, we have an opportunity. So that's why I came forward.
Question to the gentleman there that presented with you. If you could help me understand just a little, for those of us that are not versed in the post-secondary tenure process, and I'm looking at the sentence, I'm specifically looking on page 2, at the end of line 10 where your sentence starts and you say it's repeated multiple times. Show me where else it's repeated, if you would, first.
Yes, so it's on page 2, beginning on line 10, and then it is repeated page 3, beginning on line 5.
Page 3, beginning on line 5.
Yes.
Okay.
Senator Givens, if I could add, there are 3 sections of the bill. One refers to our KCTCS and comprehensives. One refers to UK, and one refers specifically to U of L. That's why there are 3 redentions of that in the bill.
Okay, good.
That's exactly right, yeah.
So, Mr. Chairman, if I could continue.
Please proceed.
Thank you, sir. Help me to understand as a layperson the process of becoming a faculty member. There's an initial employment contract at your initial time of hiring, and then tenure is how long do you work to get to the tenure point?
Yeah, thank you for asking that. So a typical tenure track path would be 6 years of, at Murray State, it's annual evaluations. They're comprehensive evaluations by your peers within your department chair, and your dean. And then once you go through the tenure process, in my case at Murray State, it's in the 6th year of your employment on the tenure track, you submit a dossier of all of your peer-reviewed research, your teaching portfolio, your service to the university and community, and that goes through at the level of the department, then at the level of the chair, a college level or school level committee of members of that committee, a tenure and promotion committee, It then goes up to the dean. It then goes to a university level committee. And then it goes to the provost, goes from the provost to the president to the board of regents or board of trustees. And only on an act of the board of regents or board of trustees would tenure be awarded at that time.
And I presume the process is going to be similar from one institution to another.
It's very standard,
Very,
yes.
very standard.
Actually, the 1940 Statement on Tenure and Academic Freedom by the AAUP is actually what is, if not written verbatim in many Board of Regents documents, bylaws and so on for defining tenure, it's very close. That 1940 statement is gold standard.
So it's during the 6th year that this process unfolds.
Yes.
And by the end of the 6th year, you know if you're going to get tenure or not?
Yeah, so I think it varies by institution. And my institution, when I received tenure, I was updated on the process. So every single time I went through a layer of that process, once the dean had approved the application, once the provost had approved the application, usually they would send you a little note. You'd hear from the president saying, congratulations, I've approved and recommended you for tenure to the board.
So, specific question that I have now that you've helped me to understand it just a little better. Measures to evaluate performance and productivity shall relate directly to the responsibilities stipulated within a president's or faculty member's employment contract.
Mm-hmm.
Do we know, is that the initial employment contract or the tenure employment contract? I presume there's a new contract after tenure is successfully achieved.
I believe anytime there's a cost of living adjustment or any kind of change to base pay, I know at my institution, I sign a new contract every year, and it includes my job duties, teaching, service, and research.
Okay, that helps me to know. So there is an annual employment contract.
I can speak to my institution. I don't know for sure at all Kentucky universities,
Okay.
but I believe that's pretty standard practice.
Very good. Thank you, Mr. Chairman.
Yes.
Got a couple questions really quickly. Just for clarification, I think I know the answer to my question, just to make sure. Tenure is not in KRS, Kentucky Revised Statutes, anywhere. Is that correct?
I believe that is correct.
I think it's mainly, it's in the bylaws.
It's in the bylaws of the board.
The universities,
Yeah.
just for clarification.
Exactly.
So with the committee sub, would you say, are we against, are you saying tenure no matter what, even upon a poor performance review?
Absolutely not. That's a really good question, actually. We very deliberately left the word tenure out of this sentence because we do realize that different universities are going to have different processes. The reason for using just the employment contract is because that process I described earlier, when you go from assistant professor to associate and you go through all those layers of evaluation, there's sometimes, there's a pretty, what you're being evaluated on going through the process. Different layers have different priorities sometimes in terms of what they're evaluating on. And once you get to the board level, they're taking the recommendations of your departmental peers, your dean, your provost, your president, and they're taking all that into consideration before weighing a final decision. And so the concern that was raised to me and members of the AAUP as well was that the possibility of having it written into law that the post-tenure review process would be established by the board with no further explanation of that. There's a risk that boards of regents, they're primarily there to take care of the fiscal duties of the university and the management of the universities. They're not meant to be also experts in English literary pedagogy and physics and all these other disciplines that we're evaluated on. So this is just to ensure the integrity of that process is sustained in the post-tenure review process. So this would keep the post-tenure review in place. It would keep the language about dismissal for cause that's added to the bill. It just makes sure that it sticks to employment contracts and nothing else.
Committee will stand at ease. Senator,
So does, two questions. One, who signs these contracts? Is it the board or is it the president or is your department head? So you get an annual contract. Who is the one that is signing these contracts?
At least at Murray State, it's the president who signs the contract annually. When you go through the tenure and promotion process, and subsequently when you go through a promotion from associate to full professor, that process is determined by the board. But at the sort of year-by-year level, that's I believe, the president.
So it seems the purpose of this is to give the board to define the performance criteria, which you say they do the first time for the tenure process, but they're on after it's the president and not the board. So are we sort of, the bill gives the board the authority to set the policy, but after the first contract, it sounds to me like it's the president and not the board with your amendment.
Well, with some unusual exceptions, generally the board takes the recommendations of the different layers of evaluation at the tenure stage. So it's a very simple process that the board will use to go through it. They'll go through the whole process. When I watched my own tenure case go through, the provost listed off the names up for consideration, had those packets in front of the board. They had a chance to look over them. The board did an up or down vote on the tenure status for each faculty member. So this would simply be about making sure that if there's an annual review process established by the board, that process is going to remain concurrent, maybe not be the right word, but concurrent with the process that's already in place for evaluating faculty. So the faculty are getting these evaluations, but it's the same kind of standards that they're held to by their department chairs, by their deans, by their provost when they're evaluated pre-tenure. So the board wouldn't be able to add anything or take anything else away.
Senator Wise.
Thank you, Mr. Chairman. Representative Tipton, this may go to you as just the primary bill sponsor before the sub. Did you work with CPE and all the university presidents on this initial bill?
I did have conversations with all those parties. None of the university came out with an official position. You can probably understand why. They don't want to cause confusion on their campuses, but I did work with CPE on the drafting of this language. If I could make a couple of comments. Originally, in the original bill in the House, I had some language about tenure. It was suggested if I'm going to do that, I need to define tenure. I'm going to be honest, there aren't a lot of good definitions, consistent definitions in statute out there, so I just chose not to mention tenure. I also made, after a conversation with one of the university presidents who shared with me, they do not actually have employment contracts. They submit letters to individuals, so I just left the term employment contract out, left it strictly as a performance and productivity review. From my study, research on tenure, that is to protect faculty members from things like freedom of speech, academic freedom. It does not protect faculty members from not showing up to work on time, from refusing to teach an online class or refusing to teach an in-person class. And that's the gist of what I wanted to get to with this performance and productivity review, because I have had many conversations over the last 9 or 10 years, and I have heard some situations that I felt like predicated introducing this legislation.
Back to my question, Mr.
Please
Chairman.
proceed.
So, Representative Tipton, have you been aware of this sub that was presented to you before coming into the meeting?
I received an email, I believe, from Mr. Horton over the weekend with this suggestion. Obviously, not being a member of the Senate Education Committee, I could take no action on it. So I was aware of it, but I was not aware that there was going to be a Senate Committee sub filed.
Okay. Senator Neal, if you don't care, was your sub presented to CPE since Representative Tipton had worked with them, that CPE has also seen the changes that you made to this piece of legislation?
No.
Thank you.
Any other questions from members? Senator Givens has another question.
Thank you, Mr. Chairman. And very briefly, Chair Tipton, I want to make sure that I heard clearly what you said, and maybe I misheard you. I think I heard through your words an indication that there may not be employment contracts. Explain again what you said a moment ago.
I had one university president share with me they did not give employment contracts per se. They issued letters. Now, I'm assuming those letters are signed. Maybe it's a matter of terminology, Senator Givens, but after that conversation, I took any reference to employment contract out of the statute.
Okay. All right, thank you.
Any other questions?
If he may elucidate on that last point, I think it might bring some clarity.
Please proceed.
Yes, thank you. I think with the term contract, I think we would also be amenable to a contract or letter, something along those lines. The idea is primarily just what faculty receive every year when they're told what they're being evaluated on by their chair, dean, provost, and president is essentially the spirit of this sub.
Senator Thomas.
Yes, just briefly, Chairman Wesley, as you know, being a lawyer yourself, a letter can be a contract and can be construed as a contract. So just
As long as it's signed appropriately.
that's right.
That's correct.
Any other questions from members? I have a question right now for Chair Tipton. Could you go into a little bit more detail as we may or may not proceed on the sub? What are your feelings on the sub? After your review of the sub, are you amenable to the sub or not?
It is my personal opinion that tenure and employment agreement are two very distinct issues. Tenure is a process that each University Board of Regents has the ability to set up. They set up the process, they make the requirements, they set up the policy, and that's unique to each individual university. Again, tenure, in my opinion, is not intended to reward poor performance, to reward actions that are not of the benefit of the Commonwealth of Kentucky. I'm only aware of one time that I've been able to find that the General Assembly has actually delved into the world of tenure, and that was in 2022 with the passage of House Bill 250, dealing with Kentucky State University. We did initiate a process for post-tenure review temporarily for KSU to right their ship. But that is the only time I can find that as a General Assembly we've actually gotten into the subject of tenure. To me, that is a policy best left up to our University Board of Regents. And again, all this bill does is it allows Board of Regents to set policy that's acceptable to them on performance and productivity.
So in your opinion, does the sub strengthen your bill or weaken your bill?
I believe it would weaken my bill. That's just my personal opinion. I'll leave the decision up to discretion of the Senate Ed Committee.
Chair West,
Please proceed.
certainly we'd like to know how that might weaken the bill. We don't understand what that might mean, but perhaps further discussion on the question that you raised may be helpful.
So unless I see further questions, this will kind of wrap it up.
Yes.
So you'll have
Understood.
the last word before
Okay.
we proceed with anything.
Yes. No, and I appreciate your point, Representative Tipton, about the distinction between tenure and universities' processes for employment contracts. Essentially, this isn't about defining tenure in statute. It's really about when tenure is in place at a university. Going back to the 1940 AAUP Statement on Academic Freedom and Tenure, which is very much the gold standard for tenure in our universities, one of the things that it talks about is the risk of the shifting political winds of the country over the years and over the decades. And boards of regents, boards of trustees, as we know, are state-appointed officials. What this is meant really to safeguard is to ensure that no matter who is in the governor's mansion, no matter who is in the legislature, the standards for the evaluation remain anchored in the contracts that are given to the faculty by their supervisors, so that there can't be any imposition of any kind of arbitrary evaluation or even unintended evaluation that isn't germane to their faculty members' work.
Senator Neal, you have a final
I'm good.
word? Okay. Any other questions from members on the bill? So we have before us House Bill 298.
424.
I'm sorry, I'm on the wrong page, 424. We have not adopted, we have the sub that we've been discussing. Freudian slip, I apologize.
With the English professor here.
Do we have any action?
Motion on the sub.
We have a motion on the sub to House Bill 424. We have a second from Senator Thomas. Action on the sub is a voice vote. All those in favor of adopting the sub say aye.
Aye.
Opposed, nay. Nay. Nays have it. Sub to House Bill 424 is not adopted.
Thank you,
gentlemen.
Thank you, Mr. Chair, and committee members.
Next, on the floor, we have work. Yes, yeah. Do we have a motion on House Bill 424? Senator Wilson, do we have a second? Second, Senator Rawlings. All those in favor of 424, please say aye to the roll.
Senator Carroll. Aye. Senator Gibbons. Aye. Senator Higdon. Senator Meredith. Senator Neal. Senator Rawlings. Senator Reed. Senator Thomas. Senator Tishner. Senator Williams. Senator Wilson. Senator Wise. Chair West.
Aye. 424 passes with favorable expression. Thank you, Representative Tippett.
Thank you, Mr. Chairman and members of the committee.
Up next on the agenda, we have House Bill 4, an act relating to initiatives regarding diversity, equity, and inclusion. I'm going to make an overall announcement so everybody knows what's happening. We have a hard stop at it'll be 11:30, 10:30, 4:30. I've had too many meetings this morning. I apologize. Did you get that? 4:30. And so the way we will allow the bill sponsor to present, and then we will have, I believe, Senator Neal will be allowed to present after that point. We're going to allow questions after your presentation. And then we have several signed up to speak against, and we will divvy out the amount of time based on how much time left we have there. But it's 4:30 is the stop, the hard stop. Please state your name for the record and proceed.
My name is Jennifer Decker. I'm the state representative from House District 58, which is Shelby County.
My name is Joe Bilby. I'm the Deputy General Counsel in the Office of the Speaker.
Floor is yours.
Thank you, Mr. Chairman and members of the committee. Today I'm here to present House Bill 4, a bill that would ensure that our post-secondary system in Kentucky is held accountable to dismantle the failed and misguided DEI bureaucracy that has made college more divided, more expensive, and less tolerant. If education is to be the great equalizer in our Commonwealth, the opportunity to obtain a college degree in our state must be equally available and affordable to all. HB 4 would allow our universities and colleges to return their focus away from social engineering to providing Kentucky students with excellent academic instruction in an environment that fosters critical thinking through open, constructive dialogue. To accomplish these goals, HB 4 narrowly targets DEI offices and initiatives that promote unconstitutional, differential treatment based on religion, race, color, sex, and national origin. DEI policies have cost taxpayers hundreds of millions of dollars over the past 14 years, a period in which Kentucky campuses have also experienced a dramatic drop in the overall enrollment of students and a dramatic drop in the enrollment of low-income Kentucky students. After my testimony before the House Post-Secondary Education Committee, one newspaper in Kentucky said that my claim of student enrollment decline was exaggerated and linked to a chart that unfortunately included statistics from Kentucky's private universities and colleges. It showed an overall increase since 2013, but the chart that was linked to skewed the drop of overall enrollment that our state institutions have had because our private schools have not had the same type of precipitous drop. If those private school enrollment increases are excluded from the report, it's clear that the dramatic drop in enrollment I cited in fact occurred. Even with recent slight enrollment gains, Kentucky's post-secondary institutions reported fewer students for 2024 than were enrolled in 2014. Accurate data reveals that since 2011, the year our post-secondary schools began DEI initiatives, we are down 23,311 students overall. While I have never said that DEI is to blame for enrollment decline, which is most dramatic in our low-income, underrepresented minority population, I have said and will continue to say that unconstitutional DEI initiatives were initiated on our campuses, perhaps with very good intent. They were meant to enroll and protect and increase our underrepresented minorities, to be more inclusive, for our campuses to be more diverse. That simply has not happened. In 2010, when the Kentucky Council of Post-Secondary Education created the first statewide DEI plan, Kentucky taxpayers were promised that DEI policies would benefit Kentucky's historically underrepresented minorities, including low-income populations. That has not happened. That enrollment has declined dramatically. Opponents of this bill misread or don't read the bill before they state their objections. I have received countless letters from opponents of the bill who state that it is terrible that the bill threatens student centers and supports for veterans, first generation, and low-income students, services that the bill specifically and explicitly exempts from the application of the bill. This bill solely aims at unconstitutional DEI initiatives, offices, and officers that promote or provide differential treatment or benefits to individuals on the basis of religion, race, color, sex, and national origin. Nothing broader on the campus. After the United States Supreme Court ruled in the 2023 case of Students for Fair Admission versus Harvard, it's clear that race-conscious preferences violate the 14th Amendment and the Civil Rights Act of 1964. In the majority opinion in that case, Chief Justice John Roberts, in the majority opinion, states eliminating racial discrimination means eliminating all of it. A continuation of unconstitutional practices would subject our state to great legal risks and students to great harm, discrimination. Taxpayers should not fund such practices, however well-intended. Historically, America has striven for equal opportunity, not subjective equity, which DEI now pursues through discriminatory admissions, hirings, and scholarships. Standards that shift with administration's whims. HB 4 would halt this dangerous unconstitutional approach, aligning Kentucky with equal protection principles upon which our nation was founded. Thank you.
Thank you so much. Right now, we'll take a brief stop, allow questions for the bill sponsor. Does anyone on the committee wish to ask Representative Decker a question? Seeing none, that may be a first. Senator Thomas, sir.
Thank you, Alex. I have one question with three parts, Mr. Chair. May I ask that question?
I think that's three questions, isn't it? Yes, you can. I'm sorry.
Thank you, Mr. Chair. As I understand House Bill 4, it would eliminate any consideration of race in the admissions by the state universities here in Kentucky. Is that correct?
It's not correct. The bill specifically says that the universities cannot solicit or make decisions based on race. But as the Supreme Court stated in the opinion in the Harvard case, if admissions candidates submit essays that talk about their race, and those admissions applications show something about the person other than race that would make the university believe they would be a good candidate, that is constitutional. It is the solicitation of that information about race. It is the decision-making based on race that is precluded.
I thought that was my question, because 1B in Section 2 says cannot take into consideration religion, race, sex, color, or national origin in student admissions. I mean, that's the wording in your proposed bill.
Where are you reading,
I'm
please?
on page 5, line 25 and 26. I'm just reading the words you have there.
They may not discriminate in student admissions on the basis of those characteristics. That doesn't mean they can't consider the race and how the person has achieved because of that. It says the decision may not be made based on those.
Race, sex,
Yes.
religion. Thank you. Part B, that question, is that public universities are now precluded from using any scholarship criteria geared to students on the basis of race, sex, religion as well. I'm reading now on top of page 6, C1. For example, let me give you an example. University of Kentucky has had a scholarship for years called the William Parker Scholarship, geared to black students who want to go to UK. Under your bill, that would now be prohibited. Am I correct on that?
The Supreme Court has not at this point specifically addressed scholarships, but again, and I'm telling you the basis of and what this inevitably means. That is, because the Supreme Court has not ruled directly on that, it is not a decided factor, except for several other reasons. It is believed that that is the ruling that will come soon. Number one, in the Harvard case, the Chief Justice did say that he believed discrimination must be, we must get rid of it altogether if we're to get rid of it at all. And then in another case that, in the concurrent opinion in that case, in fact, Justice Gorsuch, in his concurring opinion, implied that racial discrimination under Title VI could apply to all of the programs at the institution. So what this does is it protects Kentucky from that liability and our students from the discrimination that we believe will be determined to be unconstitutional.
Representative Dick, I don't believe you answered my question. I'm just reading the language. It says the institution shall not impose any scholarship criteria or scholarship eligibility restriction on or provide differential treatment or benefits to a scholarship applicant or recipient on the basis of an individual's religion, race, sex, color, and national origin. I'm just reading the words you have there.
And that is to be the law here. But on page 8 of the bill, if you will look there, starting at page 27, there is a provision that, notwithstanding that, if there are privately funded scholarships that exist before the effective date of this act, they may continue to be paid out until the corpus is exhausted.
Microphone, Senator Neal. Senator Thomas.
Yes. My final question. With regard to pamphlets, materials, written statements that would seek to encourage students to to apply to UK, geared to, say, black students or to women, would a university be allowed to do that? Because I noticed, once again, in just reading your proposed bill, that you accept statements where, or activities, programs, initiatives for military veterans, Pell Grant recipients, first-generation college students, low-income students, non-traditional students, transfer students from KCTCS, or the students with unique abilities. The university could still, as I read your letter, or read your bill, excuse me, seek to recruit those students and provide or expend monies to attract those students, but that would exclude, the way I read your bill, any activities designed to try to recruit black students or women or Hispanic students. They would seem to be excluded from that. Am I reading your bill correctly?
the bill tracks the United States Constitution and the Civil Rights Act. So if state money is expended to prefer or promote admission for racial reasons, it would be prohibited under this bill, under the Constitution, under the Civil Rights Act.
Thank you, Senator Thomas. I'm gonna jump in here real quick, Senator Neal, with a question of my own because it pertains to something that Senator Thomas stated. Just because this is very important for clarification. So, under the technical reading of the bill, it may prohibit those types of programs that Senator Thomas mentioned. Let's say there's a new scholarship program that's newly minted. We know these existing ones are grandfathered in, basically, but let's say there's a newly minted scholarship program similar to what Senator Thomas is talking about. This bill would not preclude UK from receiving the funds from the scholarship. Let's say it's from the UK endowment, U of L endowment. Let's say it's from an NAACP scholarship fund, things of that nature. It would not preclude UK from receiving those funds and the student receiving those funds. It would just preclude the university from administering the scholarship. Is that a fair statement?
Mr. Chairman, if money comes into the university from any source, it becomes resources that cannot be spent by the university for these purposes. There is nothing that would stop any of the groups you mentioned from providing those scholarships themselves at this point. But once they involve the university, it becomes a state action that is prohibited by the Constitution.
Senator Neal.
Thank you, Mr. Chairman. I just want to make sure I'm clear on this. You mentioned the Harvard case. I think in that same case, the Chief Justice indicated that race could be used along with other factors. It didn't say that they couldn't, and he didn't express an opinion that they shouldn't be. In fact, said the law is that race can be used along with other factors. I think if you have your attorney or someone with a legal background look at that, you'll find that to be the case. So my question, though, is this. What determinations been made in a court of law or by a legal tribunal of some sort in Kentucky, I'm just curious, that these programs that you've generalized to be called DEI have been invalidative of the Constitution? If you could state those, I would like to have those. I'll restate it if you don't understand the question.
I think you asked if there's been a court of law in Kentucky that has found any of this to be unconstitutional, and I don't know that the court in Kentucky would have jurisdiction over a constitutional claim. But what the United States, well, they could. You could sue in a Kentucky court for a constitution, but normally it would be in a federal case. But we don't want that to be found. We have the Harvard case that applies to the entire nation about such principles. We are only talking about initiatives that do these things, discriminate based on these characteristics. We're not talking about anything else on the campus. Our Attorney General has said that our performance-based funding was, in his opinion, unconstitutional because it did that. So we are applying the legal principles to Kentucky practices.
Mr. Chairman, I have a series of questions. I really didn't get the first one fundamentally answered, and the response is not based upon law. There is no unconstitutionality that's been determined, and the Harvard case does not establish that, and it also applies to admissions, and really doesn't apply to what this bill is trying to get to. But what I want to say is this, and I'm going to cut it short because I have another issue regarding House Bill 4, in that it severely restricts our could inadvertently restrict universities' ability to function effectively and fulfill their educational mission. And that's another piece that I think we need to deal with, and I will take that up when I present, Mr. Chairman.
Thank you. Any other members with questions this time? At this time, just to let everyone know where we are in the roadmap, we have 20 people signed up to speak on the sign-up sheet. We will try to get to as many people as we possibly can on the sign-up sheet. However, first, members of the committee take precedence. So Senator Neal, I believe you want to go down and present possibly on a sub? Okay. Do you want the sub to be presented to the committee?
I do. Thank you, sir. Yeah. We'll both use this right here. You hear the ignorance that was expressed here? Incredible.
Senator Neal, once again, both of you, please state your name for the record and proceed. If it's at all possible, if we could keep it to 5 minutes in this segment, we got a lot of people to speak again, so I'm going to try to get to everybody. Floor is yours.
Mr. Chairman, I'm a lawyer.
Does that mean this will
I'll
go a
try.
long time?
You said try. The operative term, try. Thank you, Mr. Chairman. My name is Gerald Neal. I'm serve as senator for the 33rd Senatorial District, which is in Louisville, a very diverse district in Louisville, Kentucky. I do want to preface. I'm sorry.
Oh, and I'm Dr. Ray Horton, member of the United Campus Workers.
Green button.
Oh, sorry. Thank you. Dr. Ray Horton, member of the United Campus Workers of Kentucky, and a faculty member at Murray State University in my personal capacity, and for the purposes of this discussion, also a scholar of American literature.
Thank you, Mr. Chairman. I do want to state I didn't plan to take this particular tack here in this hearing because there's going to be time, hopefully plenty of time to discuss this on the floor. But after hearing this testimony, I have to address the presentation from the standpoint that what I'm seeing here is a lack of understanding what DEI is, and I think it's been incorporated to mean something other than what I think I heard, and also that there is no unconstitutionality per se as it relates to using race as a factor. I think that's very clear in the law, and to suggest otherwise shows a lack of understanding of the law, which also takes me to, well, then what is the basis of this? Maybe this is something that someone may not like, or they may not appreciate, or maybe we're revisiting history here. And that raises a lot of questions which will be addressed not here today, but later on. My purpose today is to try to protect what our universities are about and what the power of what they provide for us in that educational setting. I think it's very important. So what I did was I looked at House Bill 4 and I inquired of Dr. Horton and others in academia and otherwise as to what is the effect of this bill in terms of what you are sent to do, what your piece is in terms of how you deliver services, how you deliver and teach individuals, how you prepare them, what kind of dynamics are involved. What do you see here outside of this question of race per se that raises a concern for you. And what the response was, almost to a person, in fact, to a person, was we're very much concerned about the bill itself, but certainly the unintended consequences. And that's what I'm here to talk about, the unintended consequences. Because this bill has been defined so broadly, and there's some other aspects of it that you're going to find in academia and pretty much across the board, that one of the things that's so seriously concerning to those institutions are the unanticipated consequences. So what I've tried to do here with consultation was to try to determine how do you limit the unintended consequences for what this bill does. And I want to make it very clear, I'm not a fan of this bill. I think it's unnecessary, and I have another thing to say about that. But I am concerned about these universities and what they do. Having taught as adjunct professor for better than 10 years myself, I understand how that works. And I think a lot of people come in conceptually and miss that point. So I want to get right to the point. And I'm going to have Professor Horton delve into this to a degree here too. If you look at the committee substitute, you're going to find some areas that were specifically identified to achieve the objective that I was talking about. It wasn't achieved, it wasn't for the purpose of defeating a bill or the intentionality of this bill, etc., but to avoid unintended consequences as a result of the language of this bill. And I will start with the First Amendment that's referred to in the committee substitute. And it says that we should delete bequests, donations, endowments, grants, gifts, and any other source. I would generally say that is a major resource of our universities. And even though it's been said here very broadly, and that's part of the problem, the lack of definition, the broad definition, I should say, that if you limit these and do not understand how this works broadly, then you may run right back into limiting the abilities of the universities to carry out with, quote unquote, the resources that are referred to broadly. Universities' financial resources are complex, and some are expressly restricted by the wishes of the donors. And this amendment guards against the unintended consequences of jeopardizing important revenue streams that contribute to the overall financial health of these institutions. If you look at Amendment 2, it deletes the words differential treatment of benefits, because that's what is differential? Not sure what that means. I do know what prejudicial or preferential treatment means, and I'm suggesting that if the wording differential is deleted and we incorporate preferential or prejudicial treatment or consideration resulting in demonstrated harm, which is what courts do, and includes the conferring of withholding of a benefit, then that would be more acceptable. That would limit that to some, and still, I think, get to what the drafter was trying to get at without unintended consequences. Schools operate under the umbrella of accreditation. They have to comply with the terms of accreditation. If you have an unaccredited school in Kentucky, you got a big problem if we're talking about advancing Kentucky in many aspects of what universities contribute to the advancement of our economy and individual growth and development, et cetera, et cetera. So here, again, I think that you have to look at this accreditation requirements of an academic program approved by the council as opposed to dictating and mandating from this level in a very broad sense, because, again, those are determinations that have to be made close to the work that takes place in the university. Councils make those decisions. They're the ones that deal with the nuances and the elements that are necessary to determine what's proper in terms of relationship of the individual's work and the university itself. So courses, it also has insert courses of extracurricular activities required by the accreditation of the academic program approved by the council. Again, it addresses that same issue. I'm going to ask Dr. Horton to jump in whenever he thinks it'd be helpful.
To the point about academic program accreditation, the bill, and it's good that it does this, carves out an exception for institutional accreditation. And I believe a lot of folks in the legislature, but also even maybe in universities, are hoping this will operate as that kind of trickles down to program accreditation as well. But we have to be very, very careful about that. Approximately, if you look into just the publicly available data on course enrollments and credit hours generated, there are 5 or 6 major programs with accrediting bodies that have some sort of diversity requirement in their accreditation standards. So nursing schools, business schools, social work, schools of education, and there's a couple others that I'm missing off the speech and language pathology. And those make up, depending on how you look at it, anywhere from like 30 to 40% of the credit hours generated at most of our universities. That ends up, credit hours generated is how many administrations and financial offices will look at tuition revenue, essentially. I heard the word dismantle used at the beginning of the presentation, and I think, I don't know anything about construction, I'm an English professor, but I do know that if you are dismantling something, you have to be careful not to pull out a load-bearing wall, and these program accreditations are, in fact, load-bearing walls for the institutions themselves. They really depend on these flagship programs: nursing, business, social work, etc.
There are a number of other things.
Microphone.
There are a number of other issues that are outlined in this committee sub. I know we got a time restriction here, and I'm trying to be sensitive to that. But also, there is in Amendment 4, if you look in the committee sub, it deals with inserting the words instead of just referring to the capacity as stated on page 8, line 18, but after the word capacity, insert additional words are faculty and staff sponsorship of student-led organizations. Specifically, the summary specifically excludes faculty and staff sponsorship of student-led organizations. Now, I assume this is to not have a connection between the student and the faculty when, in fact, I would think that's what we would want to have. We would want to have the experience and the leadership and the connectivity with the university as opposed to being devoid of that. And by the way, even if you achieve this anyway, you're going to find student organizations connecting with those who are in the faculty, et cetera. And even though they may not as this language suggests, they still will be inputting and benefiting the students, et cetera, going forward. I'm going to pick out just a couple more, and then I'm going to move off because I understand the time piece. This piece regarding curriculum and professional development. What I would suggest here is that we insert, in lieu of, let's see, it's right here, right? That we insert curriculum development into this. Is on page 8, line 8. Delete and insert. Delete the commas. That's some technical stuff. But insert curriculum development, professional development, or classroom discussions provided such activities comply with existing federal and state non-discrimination laws and with Section 2(1)(I) of this Act. And the point is that whatever we do or don't do, and it's been said here, I think mistakenly, we do have to comply with federal law. So whatever that is, we should be in compliance with this. And I would argue that if I'm wrong about what federal law is, or if federal law changes, then it is what it is. But the fact of the matter is not to specifically state this, actually, I think can lead to unintended consequences as well. So I'm gonna quit there because I think there's enough in here to read unless Dr. Horton thinks there's another piece in here he wants to address. So this attempt here is to put before this committee for consideration the ability to limit unintended consequences. If you look at the language that's used here and apply it to the bill that's before us, you'll find that it doesn't substantially change it. What it does is it defines and puts guardrails or restrictions where we could get into an area that could adversely affect not only the mission but the efficacy of our universities across the Commonwealth of Kentucky.
Thank you, Senator Neal and guest. At this time, we'll open this up very, very briefly. Open it up to Senator Neal. Questions from members for Senator Neal. Any questions? I've got one question. You talked about federal law and everything. On page 2 of the bill, it appears that the drafter, the sponsor, has explicitly carved out a long list of federal laws that this does not apply to. So would that not cover what you're talking about?
I'm not sure of that. I'm not sure after hearing the testimony what's included and what's not and what the effect of it is, because the way it's been worded and the way the responses have come from the presenter. But I would say that there would be no conflict in what I'm saying and what you said. If it excludes that and that's federal law, fine. If federal law is broader than what is outlined there, which could be the case, then I don't think that defeats the intent as well.
Here's how we're going to handle this segment. I'm going to ask you guys to kind of step aside, and I'm going to start allowing the speakers to speak in opposition, and we'll run through as many of those speakers as we can, and then we'll come back at the end and handle what you got for us.
Thank you.
Up first on our list, and I'm going to each speaker in this segment will be given 2 minutes. I'm going to go through this list, first come, first serve is how I'm going to handle this. But I am going to give the first presenters, there's 5 people from UCW and KHE. If you would prefer to get together and pick 1 or 2 people to speak on behalf of the 6, you can handle it that way. Or we can proceed right down the list and do 2 minutes each person. I'll leave that up to you. But we have UCW, Antonis, I'm going to butcher the last name, I'm sorry, but Kyprianidis is up first. You can sit down. Make sure that microphone's on. It's green light.
Hi, sorry for
There you
wasting
go,
your
you got
time. So I am Antonis Kyprianidis, but I believe I signed up for Bill 424. And if I
I'm
didn't...
sorry, you did. I apologize.
All right.
We have Bradley Price up. And if you would like, if you've determined who's going to speak next, I also have Bernadette Barton and Katie Kleinkepf, if they want to come forward at this time as well.
Can you hear me?
We can.
Okay, perfect.
Hold on just 1 second. We're going to fill up the table here. Okay. We're going to let you start first. We're going to give each person 2 minutes.
All right.
Floor is yours. State your name for the record and please proceed.
Good afternoon. My name is Bradley Price, and I'm a junior at the University of Louisville, studying English literature and Pan-African studies. I'm testifying as a private citizen. I'm not speaking on behalf of the University of Louisville, and I'm here to represent the Kentucky Student Coalition for Diversity, Equity, and Inclusion and Kentuckians for Higher Ed. I'm here because I believe it is my moral obligation as a Black student to be here and speak in opposition of House Bill 4. I believe that Appalachian students and Black students have been pinned against each other in a racist and classist move to destroy the pathways that allow these communities to gain education, which has served as a great equalizer for both of these historically minoritized communities. As a lifelong and proud resident of Lexington, Kentucky, attending the University of Louisville has provided me with an environment to see reflections of my own experience and the experience of Appalachians. As a Black student and daughter of 2 parents whose education provided them a pathway out of poverty, I understand the passage that education can provide out of the generational poverty that plagues Appalachian students and Black students alike. I have met many Appalachian classmates who came to the University of Louisville with the same goal as me. a diverse learning environment where I get the opportunity to meet people who have different life experiences than me. This has gifted me with the knowledge that we are much more alike than we are different. On February 28th, my classmate Savannah Dowell and I both organized a Day of DEI, where across every public university campus in the state of Kentucky, students held a rally to support their diversity, equity, and inclusion programs. Students from all over Kentucky, from the urban centers of Lexington and Louisville, to the Jackson Purchase in Western Kentucky, to the Appalachian Mountains in Moorhead and Richmond, all came together to say that they belong on their campus and they deserve to hold space on their campus. The passing of House Bill 4 will limit students' ability to learn about each other's communities and histories, and will continue to marginalize our already impoverished and marginalized state. I ask you to vote no against House Bill 4. Thank you.
Thank you
Do I press the button?
Thank you so much.
right, thank you.
Up next, we have Mrs. Barton. The floor is yours.
Hello, I'm Dr. Bernadette Barton, professor of sociology at Morehead State University, where I've been employed for 25 years. But I'm not here representing MSU today. I'm here with United Campus Workers and Kentuckians for Higher Education to oppose House Bill 4. My students and I enjoyed a cordial meeting with Senator West last Thursday, at which we all shared our perspectives on House Bill 4. I appreciate the opportunity to speak on the bill today. Our mission at MSU is to be a light to the mountains. We historically serve first-generation college students, mostly from Eastern Kentucky, which, as you likely know, includes some of the poorest counties in the United States. I'm concerned that House Bill 4's vague definitions of differential treatment will harm students. I'm already feeling the effect. For example, last week I learned that Women's Studies, I'm also the director of Women's Studies at my institution, must pause our Women in Art contest because of evolving legislation. This contest has been operating since I started at MSU in 2000. Similarly, I'm troubled that House Bill 4 could be interpreted to abolish student groups like the Black Gospel Ensemble, diminish scholarship opportunities like the Kentucky TRIO program, which supports disadvantaged students of all ages, and Veterans Upward Bound. House Bill 4 could even impact how we handle disability accommodations. The bill introduces a slippery slope. Universities are a big tent. We serve many people with different needs. We know best how to support student success. You have the power to vote no, or at least reduce the unintended consequences that Senator Neal so eloquently described. Please take advantage of the opportunity outlined by Senator Neal to clarify definitions and protect university funding and accreditation. I urge you not to dim our light.
Thank you so much. The floor is yours. Please state your name for the record and proceed.
Hello, I am Dr. Katie Kleinkoff. I'm testifying as a private citizen and on behalf of United Campus Workers. I'm an assistant professor of religion and humanities at the University of Louisville, but I'm not speaking for my employer. I am here to oppose HB 4. In theory, House Bill 4 appears to promote a critical education by prohibiting what it calls discriminatory concepts and indoctrination, while championing intellectual freedom and viewpoint diversity. On its face, that sounds great. Like you, I want Kentucky's universities to be accessible, affordable, intellectually rigorous environments free from discrimination and indoctrination. But here is a Baldwin quote that captures my concern. I can't believe what you say because I see what you do. As my colleagues have explained, what this bill says and what it does are miles apart. We are here to invite you to collaborate with Kentucky's students and campus workers. But make no mistake, we who are tired of waiting on Frankfurt to do the right thing are organized. Our unions, our coalitions, and our expectations for public education that works for everyone will grow every time a bill like HB 4 moves through these halls. Kentucky's universities work because we do. Vote no on HB 4 and focus on rebuilding Kentucky's universities into the world-class institutions we know they can be. Thank you.
Thank you so much. Up next, we're going to have three new presenters. Eric Ross, Kentucky Psychological Association, Janie Lindell, LWVKY, Noah Cameron, UCW. If you all would step forward at this time. Whenever you're ready, make sure your green light's on. State your name for the record. Floor is yours for 2 minutes.
Thank you. I'm Dr. Eric Russ, licensed psychologist and executive director of the Kentucky Psychological Association, representing over 1,000 psychology professionals and trainees, including psychology students and faculty across Kentucky's colleges and universities. Thank you, Chair West and members of the Education Committee for the opportunity to testify today. I'm here to strongly oppose HB 4. I noted my objections to this bill as a whole in the House and will add here that this bill will damage our ability to recruit and retain healthcare faculty, researchers, and trainees in Kentucky. HB 4 weakens our research and healthcare infrastructure and will allow other states to recruit our best and brightest. I also want to highlight serious concerns about the licensure language inserted in the committee sub in the House in Section 12 of the current bill. This language restricts the ability of licensure boards to protect the public. Limiting the ability of licensure boards to take disciplinary action related to education on diversity, equity, and inclusion creates a dangerous loophole, making it more challenging to sanction providers causing harm to their patients and clients. This section threatens the competency of our healthcare workforce and then makes it impossible for licensure boards to correct that lack of competency. While I unfortunately expect this bill to pass, I urge you to remove this section before final passage. Thank you.
Floor is yours.
My name is Noah Cameron. I'm a student from the University of Louisville here today with Kentuckians for Higher Education, testifying as a private citizen and joining in an organized protest to oppose House Bill 4. Effectively, House Bill 4 proposes legislation which would jeopardize university funding. It is also written with intensely vague and contradictory language which could allow for targeting and restrictions on free speech at universities. Beyond the only obvious talking points, the fallout caused by House Bill 4 would be enormous. At the University of Louisville, I work as an orientation staffer. During the summer, I helped to welcome thousands and thousands of freshmen to the school, countless of whom fall into categories of individuals this bill seeks to remove resources from. A highlight of orientation is a performance we host, full of skits and scenes which introduce freshmen to the diversity of that college is unavoidably full of. Quite literally, we put inclusion on stage under a spotlight. Afterwards, we host an activity where students of every background, black, white, gay, straight, poor, rich, have the opportunity to showcase their diversity. What this activity does is allow these students to see that they are not alone and feel that they are not alone. It shows them that no matter who they are, they have a home at U of L, that they are included. Should House Bill 4 pass, whole skits would have to be cut from our performance and the activity afterwards would have to be scrapped entirely. In other words, House Bill 4, which Republican legislators say would improve inclusion, will actually cause a decline in inclusion. Confronted with this reality, I witnessed a room full of my fellow orientation staff brought to tears. They were terrified and heartbroken at the prospect that these countless students who we are meant to make feel welcomed would instead feel isolated and unrepresented. Everyone deserves to feel included and no one deserves to be forgotten. We cannot let that be our world. We cannot let House Bill 4 pass. Thank you.
Floor is yours. State your name for the record.
My name is Janie Lindell. I'm with the League of Women Voters of Kentucky. I am speaking on behalf of our president, Jennifer Jackson, who is out of town at the 60th anniversary of the Civil Rights March in Selma. The quality of any product is intricately tied to the quality of its production process. HB 4's process to date is riddled with flaws, not the least of which limits public involvement in speaking to this bill. Ultimately, committee hearings should permit enough time for public testimony as a key means for the people's participation in lawmaking. Our opposition to House Bill 4 comes from a couple of the League's core values. Our work promotes full participation in our shared democracy and requires education as preparation for that civic engagement. Education also makes a mighty difference in developing individual potential and growing a strong economy for all of us. HB 4 potentially reverts to problems embedded in Kentucky's history, which clearly shows that its education and economic institutions have not served all Kentuckians equally well, and regrettably have not welcomed and empowered all. Kentucky's education, health, and economic statistics and outcomes show us that challenges remain in creating opportunities to fully deliver ongoing learning and individual development for Kentuckians of all backgrounds. The League insists that our government face those truths. In 2016, Kentucky adopted an ambitious goal of 60% post-secondary attainment by 2030, with a design to serve Kentuckians of many backgrounds. And so far, that has made a constructive difference. Retention and graduation rates are up for low-income students and for underserved minorities. HB 4 would weaken the 2030 goal, and its associated work focused on leveling the obstacles facing first-generation college students, Black and Latino students, veterans, low-income students, and students with disabilities. In addition, HB 4 threatens post-secondary institutions' academic climate, using confusing language such as discriminatory concepts and sketches a notion about indoctrination that makes courses less likely to engage frankly with history and perspectives that might require all of us to face hard truths about our past and present. Education is the one factor that can make a difference in life's civil and economic outcomes. Why would we remove or constrain programs needed to improve these outcomes for all Kentuckians, when it is critical for the future of the Commonwealth to help develop all Kentuckians' full potential? We ask that you vote no on this bill, and we remind you that flawed means produce flawed ends.
Thank you for your presentation. Up next, we have Whit Whitaker, Lexington NAACP. We have James Orlick, I believe. And we have Fanny Cox. Is Mrs. Cox here?
I think she was walking around.
Okay.
Yeah, hey, Fanny.
We'll start right to left. Mr. Whitaker, state your name for the record. Make sure your green button's on there. Floor is yours.
Yeah, my name is Whit Whitaker. I'm the president of the Lexington Fayette NAACP. And though the NAACP does oppose any DEI rollbacks, I am here on behalf of my community and those of us who are affected by it. I'm a first-generation college kid, number 2 in my high school class in Detroit, and I studied music, which was Western music. We didn't have African music, but learning that music helped me to become more well-rounded, and it allowed me to use the classical music that I learned to go forward and share the enslaved music of my ancestors in the classical arena. DEI has become this dirty word inferring favor and handouts, yet we accept nepotism, legacy programs, scholarships for other groups, and increased opportunities for the rich and those who have access and power, which creates a larger class of poor, unhoused, and uneducated at a time when many look down on Kentucky as a far less progressive educational class. Black soldiers were asked to fight in World War II, and they did not back down. Tuskegee Airmen fought bravely. They did not back down. Soldiers returned home, and policies and programs were given to white soldiers where black soldiers were left out. HBCUs were established because of the denial of educational opportunities in white institutions. The history of this country is as storied as it is painful. And if you had a white slave in your family, my heart goes out to you, but it is not the same. Yet, what brings us together is that your history, as is slavery and Jim Crow, a part of my history, both are American history education. We are not asking you to erase your history or the history of the Confederacy, African enslavement by whites, only to understand that how that painful memory still hurts and continues. Your history is education. Access to educational institutions are necessary. Education is the great equalizer. Good, bad, it is the truth, and one group should not enact erasure because it is afraid to face the truth of our past actions instead of learning and growing from them to build a better future for everyone. We are the sum of all our parts, good, bad, or indifferent. And because of my mistakes, I've learned to become more compassionate and understanding. Equal opportunity and equal protection are a great American lie if we do not hold this country and its people accountable for doing what is right. DEI is not favoritism or a handout. It is the definitive equalization of imbalances that increases accountability and awareness of personal bias that contribute to the historical erasure and degradation of educational growth that further contributes to the less educated class of Kentuckians in America. We are all in this game together. If I strike out and don't prepare my body, I strike out, that is on me, but I must be allowed to participate. And if we can't trust initiatives guided by racism, bias, favoritism, and division that the same that you accuse DEI initiatives of doing. Those of us affected by DEI are not asking for a participation trophy, just accessibility and opportunity to participate and earn our way based on our educational merit without being enslaved by the bias and continual rise of bullying systemic policies that contribute to the historic erasure and fall of our educational institutions. I respectfully ask you to please oppose House Bill 4.
Thank you so much.
Okay, so make sure the mic is on. Good afternoon, my name is James Orlick, and I'm here in my capacity as a PhD student in educational leadership and organizational development at the University of Louisville, not in my capacity as a director of grant writing and innovation for inclusive excellence, which this bill targets my position, and I would have to leave the state and my talent because of this bill. For the past 18 years, I have worked in higher education, raising millions of dollars and ensuring that higher education is a bridge to success and not a barrier. My work in equity is personal. I was raised by my grandmother in Appalachia, West Virginia, low income, and as a gay individual, I have faced a lot of challenges. What if the doors to your future were slammed shut, not because of your abilities, but because of who you are? This is what HB 4 will do. HB 4 threatens to dismantle these opportunities. While the bill makes exceptions for certain groups, it excludes African Americans, Latinx, Native American, Asian, LGBTQ+, women, and immigrant students, groups that have historically faced systemic barriers in education and the workforce. This bill's ambiguous requirements, including a state-mandated ideological survey, raises serious concerns about data validity, academic freedom, political misuse, and substantial financial cost, estimated between $500,000 and $2 million. This is a policy brief that I co-authored at the Center of Economic Education at the University of Louisville. HB 4 is unconstitutional. It explicitly disadvantaged protected classes, violating the Equal Protection Clause of the 14th Amendment of the United States, Title VI of the Civil Rights Act, by creating state-sponsored discrimination. This exclusion is unfair. My spouse is a Filipino immigrant. He does the back-breaking work that many Americans won't do, serving in healthcare and caring for our communities. Our policy should support, not shut out, those who give back every day. We must fully commit to the success of our multiracial democracy, where the contributions of all Americans are valued. Otherwise, we risk losing a generation of talented young people to the detriment of us all. I urge you to vote against HB 4. Thank you.
Good afternoon. My name is Fanny Cox, and I'm a librarian. I am a practitioner scholar. I hold the rank of full professor. If it were not for affirmative action program, but I guess affirmative action is not politically correct nowadays, so I'm not politically correct. However, if it were not for bills that HB 4 opposes, I wouldn't be here today. Reason being, I'm a first generation college student from a lower economic family. Neither one of my parents, my mother did graduate from high school, but my dad didn't. My mother was a bookkeeper. She had dreams of going to medical school. But it was a fact, it was a have to be thing that I go to college. I had to go to college. I dreamed of getting a PhD ring. My friends got a high school ring. It was a big deal in high school, getting a high school ring. But I said, no, I'm gonna wait till I get my PhD. Well, 2 masters later, I still haven't gotten that PhD, but I've started. And I hope to finish it before I retire. But my point is, if it had not been for programs that HB 4 is trying to get rid of, to eliminate, I wouldn't be here. Other people like me would not be here. I am the first African American librarian at the University of Louisville to earn tenure, the first to become a full professor, and the first librarian in all of U of L to beat out engineering and medicine and earn the faculty distinguished award for service. So again, if it were not for programs that are not like HB4, I would not be here. I would not have had the opportunity to go to school, go to college with financial help. I had to work harder because I wasn't prepared in grade school to go to college. But through exposure to other people, tutorials, you name it, I made it through college. And at Kentucky State, I was a National Science Foundation Fellow when I earned my first master's in public administration. I'm from Indiana. Don't hold that against me. But at IU, I did my undergraduate work and I earned my library science degree. So again, it goes back to my early years as a student, the foundation that I had that was available to me because of my race. If I didn't have those opportunities, I wouldn't be here, or it would have taken me longer. I'm not a spring chicken, okay, by any means. I'm like 65. So my point is, I'm still learning. I am a true lifelong learner. So I hope that, oh, by the way, I'm speaking as a private citizen, not as a member of the faculty at the University of Louisville. And I want to go back to HB 240. As a librarian, it's very important that we start our young kids reading prior to the 3rd grade. Because if you do the research about recidivism. Yeah, that word. You will see that the research tells us that if our children don't start reading by no later than the 3rd grade, they become a cycle. They get into this really bad cycle. So going back to my childhood, there was no library near me. Okay, so I didn't have that opportunity to go to a library. And here Mr. Truitt talked about Mr. Williams, I believe it was, talking about homeschooling, how you've homeschooled your kids. But do you take them to the library? Just asking. But I'm very proud to say the things I've done in my career has done nothing but help other people to learn, to read. As a children's librarian, I enjoyed working with the 3-year-old preschoolers, because number one, I got to see how they take things in. You want to work with 3-year-olds? They're the most honest, receptive little fellows you ever. My worst audience was 3-year-olds. I won't go into it, but ask me. I got all kind of jokes to tell you about the 3-year-olds and what they like to do, what they don't like. But I want to get to the point. When I first arrived here in Kentucky, 1999, Kentucky's reading was rated 49th. Here we are in 2024, and Kentucky's ranked has moved up to 33. That's out of 50 states, right? But when you look at the overall, that includes math and reading, its average is 38. We're still talking about 38 out of 50, okay? So now, here in 2024, we have 261,751 students. There has been a 10% decline since 2010 of our students going to college here in Kentucky. So when we talk about getting rid of programs that promote diversity, and we're talking to all aspects of diversity, we're talking about the possibility of losing more and more students who come from a background who could be that new first-generation college student, could be a returning college student, could be a number of things. Every definition or every criteria that you mentioned, we are probably excluding that person who could bring money into the tax system. Okay, because when we talk about taxes, you're talking about someone who is earning. And we want to increase our tax base, don't we? I mean, that is why y'all do taxes, right? I'm just saying. But to be economically inclined, we need an educated workforce. We need people who can read and write and do arithmetic, basic. But when you have a state that is the 1/4 below the national average, that's not a good thing. That's not a good look. What does that say about how do people perceive us outside of Kentucky being that low?
Ms. Cox, you're a little bit over the 2 minutes.
Okay, I'm done.
But we're going to have to end right there. We've got, we're up against a hard stop because we got 3 members that have to go to Appropriations and Revenue. One of those being Senator Neal. What we're going to do right now is, Senator Neal, if you want to go back down to the table and to address your committee sub, we'll handle that right now. We did our best to get through the list. I think we got 11 of the 20, but we did our best. So if you could just sum up your presentation of your sub.
You know, I can say nothing better than what the witnesses have said in addition to what we said earlier. So all I want to do is say that I think this is very important. I hope that we don't take ideological positions on what I presented here today, because I think if you look at it, I think that you'll find that there's a benefit to what we all are about in terms of our university system. And that being said, I would move adoption of the sub.
So we have a motion on the sub. We have a second on the sub. Before we proceed, I do have to ask the bill sponsor to step forward and chime in on her opinion of the sub. I think it's only fair to ask the bill sponsor what they think of the sub. Floor is yours.
Thank you, Mr. Chairman. I appreciate the thought behind the sub. I think every provision of the substitute would weaken or be repetitive of what is already in the bill, so I would think it is not, I would ask the committee to vote no.
Thank you. We have a motion on the sub. We have a second on the sub. We will proceed right now with a vote. This is a voice vote. All those in favor of adopting the sub say aye.
Aye.
Those opposed, no. Noes have it. Sub is not adopted. Next, we have action on the bill. Do we have a motion on the bill from any member? Motion. We have a motion from Senator Tishner. Do we have a second? Second. Second from Senator Rawlings. Please call the roll.
Senator Carroll.
Aye.
Senator Givens. Senator Higdon. Senator Meredith. Senator Neal.
I'd like to explain my no vote.
Please proceed.
Mr. Chairman, members, I'm not a name caller. I'm not going to start now. But I am going to say to you is that we're saying a whole lot about ourselves here. We're saying a whole lot about ourselves here, and I'm hoping we can reclaim ourselves, because I know there are good people here, and I will continue to reach to you because you know what I'm talking about.
Thank you.
Senator Rawlings,
May I comment on my yes vote?
Please proceed. Under 3 minutes.
I see a number of shirts here with a clenched fist. And to me, that is very symbolic of the modern DEI movement. Thank you.
Senator Reed, Senator Thomas,
Mr. Chair, I'd like to explain my no vote, please.
Please proceed.
I'm going to begin where the Fayette County NAACP president began, and that's with a little bit of history. From the time we created public universities here in Kentucky in 1865 to 1949, blacks were not allowed at those universities. That was the law. And I cannot think of any more discriminatory concept of differential treatment than saying you aren't welcome because you're black. Finally, blacks were allowed into public universities beginning in 1949, but they just trickled in. And I've heard stories because my grandmother was one of those pioneers, okay, and how tough it was to be accepted there. Finally, around 1968-70, when President Singletary came to UK, he said, I want to change the color of UK. And he worked with leaders in Lexington to try to get more blacks and more black faculty into UK, and was very successful in that area. And we have seen from 1980 until present day an increase in enrollment at University of Kentucky among black students and a variety of students, Hispanics, Asians, LGBTQ, women, you name it. But today, we seek to reverse history and go back to our ugly past. Okay? Let's make no doubt about it. This bill is about race and about its intention to really change the course of history. We want to put on the front door of these public universities, you are not welcome. Application denied. Just a few months ago, this very committee sat and listened to university presidents from UK, U of L, Eastern, Morehead, and Murray State. And I asked the question, since the Harvard decision, have you seen a decline in your enrollment of black students? And all of them said yes. So we're already starting to see a decline in black students at these state universities. Okay. Now, you heard some misinformation here today, which is not surprising. College enrollment is up at UK, and just ask the Council on Post-Secondary Education. Our enrollment is up, but our black enrollment is slowly declining. And after today, it will continue to decline. And the intent of this bill is to see it decline continuously, as I've already said. I think, as I close, I think one point needs to be mentioned. Even though this bill paints race with a broad brush, since we started with diversity, equity, inclusion, the biggest beneficiary of that noble principle has been women. I mean, if you look at who's benefited through public education, the best in terms of admissions, numbers, faculty, administrators, it's been women. But this bill will jeopardize that progress as well.
Thank you. I think that's a 3-minute vote explanation. You're about there.
But Mac,
I'll let you finish, Senator.
Thank you, Mr. Chair. I'm gonna say this: despite the attempts to be made by this, and despite the shameful actions that are going to be taken by this legislature, as has been said earlier, we are not going to retrench. We are not going to go back. And whatever happens, we're going to push for a better day and a better tomorrow. I vote no.
Senator Tishner? Senator Williams?
Like to explain my yes vote.
Please proceed under 3 minutes.
Say my yes vote. Hey, I want to thank Ms. Cox for the call out there. Homeschoolers definitely use the public libraries all the time. It's their school library. My wife actually is applying to be on the board of a local public library, so I understand how important and appreciate how important librarians are to our communities. And quite frankly, I think regardless of this, what you showed in your determination and your insight, you would have achieved this regardless of whether this legislation is passed or not. The other thing I want to say is that we're in a situation these days where I don't know that we need a greater enrollment in universities. Our career and technical students have, I worked with housing, building, constructions. We want a housing crisis. You want to solve the housing crisis? You build houses. To build houses, you need workers to build houses. And those workers that apprentice and by 21 are journeymen and working a good career and good money, and they don't need forgiveness of their loans because they're making money and they're putting it in the bank. That is something that you need to pay attention to. The universities may have outpriced themselves economically in the value they give. I didn't hear you talking about STEM or other things. There's a lot of value in that. But quite frankly, we have forgot the working man. And that is who has built this society, is the working man out there working at 16. And so I would encourage you to take a strong look at who really has built our society and who's really going to carry us through this housing crisis and the things we've done in the future. So I vote yay, and I hope that we can support career and technical education for students throughout their careers. It's a good thing to do. And they can always go to the public library and learn and learn and learn.
That's women. Women built society.
Have decorum in the room. Proceed.
Senator Wilson? Senator Wise? Chair West?
Aye. House Bill 4 passes with favorable expression. Thank you, Representative Decker, for the presentation.
Thank you, Mr. Chairman. Thank you.
This committee's adjourned.
No, we'll go outside. Yeah, we'll go. Yeah, if you could go first. Yeah. Yeah.